Today is June 27th, 2022. My name is Rob Carr of Kalamazoo Right to Life, and this is Pro-Life Week. Well, here it is, a Monday, and we are now living in a post-Roe v. Wade world. Needless to say, the other side is still complaining, demonstrating, screaming, protesting, some doing acts of violence, cutting themselves, just screaming. They're just overwhelmed at the loss, at least from their point of view, the loss of legal abortion. But today I just want to talk briefly about the Dobbs decision, because the other side, the pro-abortion people, are making some outlandish claims, whether it's the mainstream media or the liberal Democrats in Congress or other liberal commentators. They're making statements that are just not true. And I thought I would just touch on them briefly in today's program. But first, I do want to read portions of the Dobbs decision. The first 6 pages of this 210-page opinion is the syllabus, which is basically a summary of what Justice Alito's majority opinion is going to explain. It's just a summary. And then he'll spend the next 65 pages going into much more detail regarding each one of these points. But I thought I would just briefly read portions of the summary that doesn't go into all the weeds necessarily, the minutia of legalese. So I'll just kind of get started here. In the beginning, I think it's in the second paragraph, and I'm not sure actually who wrote the syllabus, whether it was Alito or it was just the 5 justices in the majority. I'm just not sure. But let's assume, for the sake of argument, that it was Alito that wrote the summary. So he says here in the second paragraph, quote, "The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis." Remember, stare decisis is this Latin term that means let the decision stand. It's this legal doctrine that says the courts should adhere to the previous Supreme Court precedents in these cases. And after Roe v. Wade, you had several abortion-related cases, and they all adhered to stare decisis to uphold these cases based on Roe v. Wade. So let me get back to this. So in Casey's controlling opinion, they skipped over the question and reaffirmed Roe solely on the basis of stare decisis. A proper application of stare decisis, however, requires an assessment of the strength on the grounds on which Roe was based. The court, therefore, that is current court, therefore turns to the question that the Casey plurality did not consider. Okay. The majority listed several objections that had been contained in Roe. This is from page 3 of the summary, or the syllabus. Quote, "The court finds the 14th Amendment clearly does not protect the right to an abortion. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion had long been a crime in every single state. In common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have had very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, that's 1868, 3/4 of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Now, on page 4, the syllabus describes how Roe and Casey, quote, struck a particular balance between a supposed balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate, now I'm reading from page 4, but the people of the various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. The syllabus lists 5 factors the court used to overturn Roe and Casey. 1, the nature of the court's error. 2, the quality of the reasoning. 3, workability. 4, the effect on other areas of the law. 5, reliance interests. Now, those are kind of technical terms that I can't go into a lot of detail. But regarding the first, this is what the court wrote in the syllabus. Quote, like the infamous decision in Plessy versus Ferguson, Roe was egregiously wrong and on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, calling both sides of the national controversy to resolve their debate. But in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who disagreed with Roe. That's page 5. Now, for the second point, the quality of the reasoning, the syllabus states, quote, sorry I'm doing a lot of reading here, but they say it a whole lot better than I do. Quote, without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy divided into trimesters, much like those that one might expect to find in statute or regulation. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what is said about the common law was simply wrong. Now, this is me talking here. The court in Casey reaffirmed Roe's central holdings, but replaced the trimester standard for a new and obscure undue burden test. Regarding this undue burden, the syllabus states that it too, quote, had no firm grounding in constitutional text, history, or precedent, unquote. So let me just briefly go through a few false or misleading assumptions. Number 1, abortion has now been outlawed. Well, that is not true. The Dobbs decision sends the issue back to the states, and individual state legislatures will have the obligation or the duty to establish abortion policy. Some states will maintain very liberal abortion laws, and some states will have very conservative ones. But this decision did not outlaw abortion. 2, this is the first time that a fundamental right has been taken away from people. Well, I beg to disagree with that. The U.S. Constitution, Article 1, Section 2, Clause 3, deals with the House of Representatives based on population census. Quote, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years. That would be like an indentured servant, but not a slave. And excluding Indians not taxed, 3/5 of all other persons. So here's this 3/5 rule that's in the Constitution. Black slaves would be counted for apportionment for Congress based on a different configuration. Every black slave counted as 3/5 of a white person. So 100 white people would be 100 white votes, 100 persons. But 100 blacks would be counted as 60 persons. Turning to Article 4, Section 2, Clause 3, it says, no person held to service or labor in one state, escaping into another, shall in consequence of any law or regulation, shall be delivered up on claim of the party to whom such service or labor may be due. This is this whole issue of the Fugitive Slave Act, where if you're a runaway black slave going from Mississippi up to Illinois, marshals could come north where slavery was outlawed and capture that slave and bring him back to the South. And then that's the whole genesis of the Underground Railroad, getting these black slaves into freedom and into Canada to escape slavery. But this was invalidated by the 13th Amendment of 1865 that prohibited slavery. So, in a sense, the 13th Amendment took away a fundamental right that had been guaranteed since 1787, the year the Constitution was ratified. The right to own slaves. White slave owners relied on that right. Their livelihood, their income, their status in the community was based on their reliance on their right to own and hold black slaves, to treat them like property, to sell them, to buy them, to break up families, if desired, for their own personal and financial benefit. They held that right. But then in 1865, they lost it. They lost that right to own slaves. It was taken away. So was it a fundamental right for them? Yes, it was a fundamental right to own slaves prior to 1865. Number 3, this is an illegitimate court. No, all the justices on the court were confirmed by the Senate. The argument was that both Trump and George W. Bush were elected without getting the majority popular vote. But they still were able to put justices on the court. Bush got Sam Alito, who wrote the Dobbs decision, and Chief Justice John Roberts. And of course, we know Trump got 3 justices, Gorsuch, Kavanaugh, and Barrett. Our system is not based on popular vote, but based on the Electoral College. The last item here, women will die without abortion. No. Since the 1940s, the number of abortion-related maternal deaths has dropped dramatically. In 1972, there were 39 maternal deaths related to abortion. And penicillin, which was discovered in the 1940s, is the main reason why the number of abortion-related deaths has dropped dramatically. Who dies in abortions? It's not the mother. It's the baby. Now up to 63 million since 1973. In every abortion, 2 people enter a clinic, the mother and her baby. Only 1 comes out alive. Babies, not mothers, babies are dying from abortion. With that, I'll let you go. Remember, don't sign that petition. We're coming down to the wire on this petition drive. Don't sign it. With that, I'll let you go, and I'll see you next time.